Welcome to Your Money Guides, brought to you by Interface Financial Planning. In this guide, I'm going to be talking about making your will and the important decisions you need to make. Having taken the decision to make your will, possibly for the first time, there are a few points you should consider before committing yourself to an appointment with a professional will writer. The first point is making important decisions. The consultant's job is to take your instructions and translate these into your will, creating a document which will accurately reflect your wishes. The will needs to be understood by your executors, and most importantly the probate court. This ensures that it's proved quickly, and it minimises any problems which may occur, causing delays and possible hardship to your loved ones. There are some important questions which you need to consider before meeting with your consultant. By having many of the answers available, it will leave more time to discuss the other important issues which may arise during the consultation. You also need to consider the appointment of executors and trustees. You do not need to appoint other professionals to act as an executor or trustee of your estate unless there is the likelihood of a trust arising. In many cases, it would be sufficient to appoint your spouse or partner together with a member of your family, a prime beneficiary, or close friends to act. Remember, an executor can also be a beneficiary. If you do need to appoint a professional executor, you could consider appointing a trust corporation, such as the SWW Trust Corporation, or a solicitor to act on your behalf. Your consultant will be able to advise you on the best choice given your circumstances, and give you a guide to the fees they are likely to charge. As well as executors and trustees, you may also need to appoint a guardian. If you have minor children under the age of 18 years old, you will need to appoint a guardian. It may be helpful to make at least one guardian a joint trustee. They'll have a right to money from your estate to help towards the cost of bringing up your children. If you wish to restrict the amount which they are entitled, it may be wise to leave the money in trust. Again, your consultant will be able to advise on the suitability of such a scheme. If you have disabled children who are likely to require specialist care, either at home or in the care of the local authority, a trust will be required to ensure that adequate funds are available for their future. There are several trust companies run by charities which can help. The Society of Will Writers can give you individual advice in these circumstances. You will also need to consider property when making your will. How you hold your property will determine how it passes on after your death. As joint tenants, your share will pass to the survivor automatically and cannot pass by your will. If you wish to pass the interest in the property to your children or others, you should hold your property as tenants in common. Your consultant will be able to advise you how this can be done. By holding the property as tenants in common, you are free to dispose of your individual shares via your will and to who you wish. Severing a joint tenancy, as it's called, can protect part of your estate from the unforeseen, such as protecting your share of an estate should your spouse or partner marry or remarry after your death, or should you or your spouse or partner go into full-time residential care. Other considerations to take into account when writing your will include special gifts. Decide now if you wish to leave any other members of your family or friends a special gift. There's also pecuniary legacies. This is the term for a gift of money. Again, give some thought as to anyone other than your spouse or children who you may wish to leave a legacy to. This can also include gifts to your favourite charity. If it is a charity, try and have the address and registration number available. Residuary legacy covers all the remainder of your estate, and in the case of a married couple, passes each to another, and then on to the children in equal shares upon the death of the survivor. You also need to consider long stop. This is also described as the total calamity or disaster clause, so called because these beneficiaries will only inherit if all those named as your residuary beneficiaries fail to survive you. You should also think about funeral wishes. You may choose to ignore this, but for those that wish to leave specific instructions, such as cremation or burial, and whether flowers or donations are to be given, it must be pointed out that whatever your request, these are only a wish and not binding on your executors to carry them out if they are unable to do so. And finally, whatever you put in your will, it's personal only to you. Make sure that your executors can find it when the time comes. Tell them where you keep your will and how they can get access to it. Thank you for listening. For more information, visit our website at interfacefinancialplanning.co.uk.